20th. All right.
I don't expect him appearing. We haven't been able to contact him. A few years, we believe he's homeless. And I do have one witness.
So are you ready to proceed?
I'm ready.
All right, bring up your client.
Ms. Dodson, do I need to bring up the witness or swear in later?
You have a witness, Ms. Dodson. Come on up. All right, this shows he was delivered a copy of the summons on the 20th day of December.
Yes, sir.
This is from 2021?
Yes, sir.
And you served a copy of the motion, the notice setting a motion for default on the, all right. All right, all those who are going to testify, raise your right hand. Let's place you under oath. All right, put on your proof.
Ms. Dodson, will you state your full name, please?
Laurel Ann Dotson.
Okay, and you presented with my office certain statistical information that was incorporated into the complaint. Still true and correct. Information, knowledge, and belief.
Sir.
Okay, and you allege inappropriate marital conduct in the divorce. Could you describe to this his honor what creates the grounds for inappropriate marital conduct? If you just go back over the last 6 to 8 months of the relationship.
Just quit coming home, starting out on drugs, in and out of jail, and then I didn't see him again.
And the divorce complaint says that you all separated in 2015. So is that true?
Yes.
And over the last, before he was served, when was the last time you saw or heard from Mr. Dotson?
5 years ago, he stopped by to try to take Allie, our daughter, to go spend the night with him, and she didn't want to go, and I haven't seen him since.
Okay, and has he left you without helping you in paying bills or rearing the children or anything?
I haven't seen or heard from him. I've got nothing.
Okay, now, do you all have two minor children left?
I have one,
One minor child left, and what's her name?
Aaliyah Dotson.
And how old is she?
She is 13.
What's her date of birth?
6/20/11.
Okay, and you had signed and notarized a proposed parenting plan that's been filed with this court. Would you like to adopt that?
Yes.
Okay, and you had you're not aware if he's worked or anything or has a job or any income.
The only thing I know is he's in the homeless camps. I don't know of any employment.
Okay, and you've also tried to find him in that homeless camp and couldn't find him there.
I've tried through his sister, who also hangs out in that area, and I
And what
No
was
luck.
your gross yearly income for 2020?
around 21,000.
Okay, all right, so around 21,000, and he probably makes zero. So I guess, Your Honor, we input his income to $1,256.66.
You would impute it according to minimum wage, is that what
Yes.
you're saying? All right.
Okay. Now, in the proposed permanent parenting plan, you have 365 days to his zero, and that you're proposing that if he wants parenting time or if he comes back around, he's going to have to file an appropriate petition.
Continuance granted because counsel's out of state. Judicial Etiquette 101. Courts avoid sandbagging a party when their lawyer can't appear. Quick check. Should there be hard limits on last-minute?
With the court. Now, there's also another issue. Did you have a child during the marriage? Okay, and who is the father of that child?
Jan Darwin Black.
And do you know where he lives now?
I do.
Have you been searching to find him since the child was born? Has it been difficult to?
Is the child that you're talking about not one that's on the parenting plan?
He's not one on the parenting plan, Your Honor, and we are filing a petition because we think we know where he is in Stewart County to have him served with that. So Mr. Dotson can be disestablished as the father.
Well, you've alleged in your complaint there are two children born. One's now an adult. One is 14. Is that correct?
And then now there's a
4-year-old.
4-year-old boy that's not Mr. Dotson's.
Well, that child is not a part of it yet. You don't allege that,
No, I
even
don't.
the existence of that child. So there's no reason to go into that. You're going to have to deal with that in a separate proceeding.
We're going to do that in juvenile court in Stewart County. All right. Now, is there any furniture, furnishings, personal belongings, or anything that he has of yours, or you have of his? Y'all have same bank accounts, anything? Y'all have anything together?
No.
Okay. Not even a 4? All right, Your Honor. I would pass the witness.
I don't have any questions. You want to put on your other proof?
Okay. Sir, what's your name?
Tracy DeMoe.
And how long have you known Ms. Dotson?
Last 3.5 years.
Okay.
My ex-wife takes care of it.
Okay. And are you, did you listen to her testimony? Does it seem like that was fairly, you cooperate with some of that stuff? What do you mean by that?
She works herself, she cleans my house, she works at a farm of a good friend of mine, Ms. Chambers. It's a sanctuary. She works at the popcorn place. She works herself to death.
And do you know of Mr. Dotson being around?
Never seen him.
Never seen him?
Never.
She's been left having to rear the children herself?
All right. Ms. Dodson will be awarded an absolute divorce on the grounds of inappropriate marital conduct. She's awarded all personal property in her possession. He is ordered to pay any debts that may be incurred in his individual name, and Ms. Dodson will pay any debts in her name. I will adopt her proposed parenting plan designating her as the primary residential parent for the one remaining minor child. Child support will be set based on the proof of the income, which, according to what I'm understanding, is minimum wage for him and $21,000 a year for her, 0 days for him, 365 days for her. And I assume that is your child covered by a 10 carer?
Yes.
Okay. And there's no insurance issues. She'll continue to be under that.
Do I need to do a whole new parenting plan? Or?
No, we can use the parenting plan you've got. Well, yeah, you probably should do a new parenting plan because this one's marked as filed as a proposed.
Okay.
This one, you need to put one that's final parenting plan.
I'll do it.
All right.
Thank you, Judge.
Thank you. Call the next case.
Good morning, Your Honor.
Good
This is
morning.
actually an easy one this morning. This is a motion for judgment by default. This is an action to quiet title. Ms. Ferris, the plaintiff, was married to a Patrick Cale Ham. They were divorced before this court in 1994 on the grounds of irreconcilable differences. Their MDA, which was incorporated into the final decree, provided for their continued co-ownership of certain real property as co-tenants with right of survivorship, but neither the MDA nor the decree gave the kind of specific deed reference that would allow an otherwise ignorant title examiner to confirm exactly which dirt was being talked about. And Ms. Ferris is now enjoying unmarketable title to that property, so that's what we've done. The defendants to this action are, of course, the known devisees of Mr. Cam, as well as all unknown heirs and devisees. We've served the ones that we knew of personally. We also served the unknowns as well as the out-of-state defendants by publication. 30 days has passed since the fourth publication in the newspaper, and we are asking the court to enter judgment by default.
All right, your motion for judgment by default is granted since there was no opposition filed.
Thank you, Your Honor.
Thank
I have
you.
a proposed order, which, yeah.
Thank you.
Judge sets a show up or shut down deadline. Be here Friday or motions get dismissed. Translation, you can't file to stall an MDA and then ghost the hearing. Fair call or too harsh?
Signed your order, Mr. Regent.
Thank you, Your Honor.
Thank you.
I represent Melissa Eccles, who is the surviving spouse of James Ricky Eccles. We filed a motion just to deem the assets distributed as has been indicated on the inventory that we filed, or alternatively, that the property previously received by the surviving son, who is Miss Jackson Smith's client, be returned to the estate and there be a sale of all property on the inventory and the proceeds deposited with the court for determination of how they need to be distributed. That's kind of based upon the fact that the inventory was filed more than 10 months ago and just it's personal property, and Ms. Eccles, quite frankly, just wants to stay closed and not have this to be a continuing issue.
Ms. Smith?
Yes, sir, Your Honor. I emailed Mr. Odell back in March and asked for a clarified version of the inventory because the inventory that was filed with the court, along with his application for letters of administration, was notated in some areas which were illegible. It had already been typed, and I asked for a Word document so that I could go over it with my client. I never received a response to that email. And I received Mr. Odell's motion set for today. I let him know that I was not available today. In fact, right now I'm supposed to be in a doctor's office in Nashville, Tennessee. And also reminded him that I had requested a Word document that clarified what was in the inventory. He advised me that I did not need a copy of the inventory, that one had been filed with the court. Your Honor, like I said, it is notated. Not only is it notated in handwriting, but it is notated in handwriting that is difficult to read. Some of it is scratched out. It is also our position, Your Honor, that some of the personal property that is currently in the possession of the administrator does belong to Mr. Eccles, my client. My goal, again, was to go through the inventory with my client, have him identify which items of personal property he believed to be his, and then to discuss those items with Mr. Odell. I would also point out, Your Honor, that there has been a significant delay in this case. When I lost my assistant, I associated my father on this case, and he had the case upon his decease. And it took a little while for the executrix to locate the file, and provide it to me so that we could begin the process. It's not at all our desire to delay this process. My client is pretty clear on what personal items he believes to be his, but I saw no point in going through an inventory that I was not sure was complete or that I completely understood to be able to explain to my client.
Let me interrupt you and just say, the court file contains an inventory that is not notated on at all. It's very clear.
Well, I can show you my copy, Judge.
No, I'm just saying though, if you need to get a copy of this, there's no other reason, the clerk can make you a copy today. And when you leave here, unless you need to head out as quickly as you can to get to the doctor, but you can have the clerk mail you an unnotated copy. But obviously, you would have the right to have that copy. It sounds like to me this is premature to close the estate. It's also premature to order the return of property. I'm going to allow Ms. Smith to have an opportunity to have a clear copy of the inventory, and you can obtain that from the clerk if you choose to today. And then from that point forward, I'll allow you to try to resolve the issue, and if not, you can set your motions back on the docket.
In the court file was served on Ms. Jackson Smith on August 2nd, 2023.
Well, doesn't matter, we're gonna give her,
I'm looking at it, Judge. I mean, I didn't notate
we can
it.
give you a legible copy today, and that solves the problem, so. If you'll see the clerk, she'll give you a copy of that, and you'll have the clerk run a copy of the inventory, your deputy clerk run a copy of the inventory, please.
Thank you, Your Honor. That
Right.
concludes my business.
Yes, ma'am.
Power move. She opposes the reset. In family court, delays can feel like control tactics, especially when an MDA clocks a hard 90-day deadline. Have you ever seen a delay used as leverage?
Good morning. Both of you raise your right hand. Let's place you under oath. One question that I have, you have filed a proposed parenting plan as required by law, and you have shown the incomes that each of you have, that the father's gross income is $3,400, the mother's is $2,560, and that the father will pay child support, but the amount that you that's supposed to be paid according to the child support guidelines would be $315 a month, and that was not filled in on this copy. Do you have another copy of the parenting plan that has the amount filled in correctly?
I was told to bring this, then on completion of the child parenting class.
Right, those are two different things. The parenting plan that you have filed is supposed to be a part of the final decree, and I can sign off on this one, but I need you to agree that I can fill in the $315 a month. Is there any dispute about that being the correct amount of monthly child support? That's according to the child support calculations that you attached. All right, then I will fill in $315 a month. All right, and I'm going to initial that as having been done. That will be paid monthly. All right, then have you placed them under oath? All right. You are Amy Nicole DePaz. Ms. DePaz, you have filed a complaint for divorce that's using a form the state provides online to individuals wishing to represent themselves. That contains certain statistical information. Is all of that information true and correct? You have also supplied to the court a marital dissolution agreement, also known as a divorce agreement, and that contains certain representations, including your signatures. Is that your signature on that agreement? Do you believe that agreement fairly and equitably divides all of your property and distributes all of your debts? Is there anything between you and Mr. DePaz that is not, Mr. DePaz Fuentes, that is not agreed upon? All right, and are you Hector Anibal DePaz Fuentes?
Yes, sir.
And do you agree that that is your signature on the marital dissolution agreement?
Yes, sir.
Do you believe that agreement fairly and equitably divides all your property and distributes all your debts?
Yes.
Do you Mrs. DePaz, do you believe that the parenting plan you have filed with the court is in your child's best interest? And you're asking me to, I believe you've signed off on it, both of you. Yes. All right, Mr. DePaz, do you believe that marital dissolution agreement also is in the best interest of your child? All right. I need a final decree of divorce. Have you prepared a final decree?
He just told me to read.
Let me see what you have, and I'll. All right. You're going to have to fill out portions of this. You're both here, so both of you will need to fill in on the first page. Both of you need to fill in your addresses.
Not to touch it until.
Okay. Both of you have signed off on it, so I just need you to fill out that front sheet that has the address. Are you changing your last name? If you'll just put your addresses on the front page and hand that back to the bailiff, then I will grant your divorce and sign off on it. You'll have a seat and do that at the table while I can take up the next case. You'll raise your right hand and be placed under oath, please. I have a question for you about your parenting plan. You don't show the father having any income. Do you know where the father is? Do you have any information about his income whatsoever?
Doesn't have any of the last name.
Okay, you don't think he has any income. Do you know where he is? Okay. So is there some reason he's not working?
I have no idea.
Under the law, he has an obligation to pay child support regardless of whether he's working or not, unless he has some verifiable disability that prevents him from being able to work and supply support for the minor child. Your parenting plan does not provide for any day-to-day schedule. A parenting plan that the court has to approve rather, should reflect, when the child is with you, when the child is with him, so that it's a verifiable, something that if an issue arises, then it can be brought back before the court and the court can enforce that order.
Right now, he has no contact with our daughter.
Okay. How old is your daughter? And he has no contact whatsoever? But yet you have, under the schedule set forth below, each parent will spend the following number of days with the minor children. And you have 12 days for you and 7 days for him.
Those were the days that we had agreed upon when he agreed to do it. Then he just stopped